Hello and welcome to another webinar in Fieldfisher's Get Data Protection Fit series. My name is Michael Brown and I'm a Senior Associate in our Privacy, Security and Information Law team. This is part of our Get Data Protection Fit series. As a brief recap, so far we've completed Module 1, which covers the fundamentals of data protection law. We are now on to putting these concepts into practice. Module 2A is complete. And we are now on segment 6 of Module 2B, still focusing on putting data protection into practice. Today we are looking at how to handle a data protection regulatory investigation. All of our previous modules are available on our YouTube channel. So, one of the broader trends in data protection law has been the ramping up of the role of data protection authorities. Most listeners will be aware of the DPA's corrective measures, including most notably the headline grabbing power to fine up to 20 million euros or 4% of annual global group turnover in the preceding financial year. However, prior to issuing such corrective measures, DPAs will, of course, have to investigate the potential non-compliance. And that's the focus of this segment, which is composed of 4 different learning outcomes. By the end of this session, you should be able to do the following. 1. Explain a data protection regulator's investigative powers. 2. Explain the UK Information Commissioner's Officer's general approach to investigations. 3. Understand how to handle an inspection. And 4. Provide general pointers on dealing with an investigation. Some other general comments. As an English qualified lawyer, I'll be concentrating on investigations by the UK ICO. The UK ICO, of course, regulates a broad range of legislation, from the Network and Information Systems Regulations to the Freedom of Information Act to, of course, the UK Data Protection Act 2018. I'll be focusing on investigations relating to data protection law, but hope that this session is still of broad utility if your organisation is being investigated by the ICO in relation to other laws. Therefore, as a reminder, Article 58 of the GDPR sets out the investigative powers of each data protection authority. There are 6 in total. The powers do dovetail and overlap somewhat, but in practice seem to focus on 2 core areas. 1, remote information gathering, and 2, on-site inspections. Now I'll just run through the powers in the order set out in Article 58 of the GDPR. First, a DPA can order the provision of any information, so that's personal data as well as non-personal data, required for the performance of its tasks. Therefore, a broad information gathering power which concerns a controller and or a processor, as well as potentially their representative if they're not established in Europe. Second, a DPA can carry out investigations in the form of data protection audits. These can be remote or on-site. Third, a DPA can carry out reviews of certifications issued under the GDPR. As a reminder, the GDPR allows for certifications for the purpose of demonstrating compliance with the law. There's not been much movement in this area, and so likely to be a very infrequently used power in the short term. Fourth, a DPA can notify the controller or processor of an alleged infringement of the GDPR. Often this is accompanied by the exercise of another power, for example, asking for information and highlighting the alleged non-compliance. Fifth, a DPA can obtain from the controller or processor access to all personal data and information necessary for the performance of its tasks. So similar to the first power I identified. Sixth, and finally, a DPA can obtain access to any premises of the controller and processor, including to any data processing equipment and means in accordance with union or member state procedural law. So those are the powers. What might the ICO actually do in practice? Well, the ICO has non-formal means and formal means of exercising its powers. Non-formal would be a request in writing for information, whereas formal would be an information notice and or assessment notice. And we'll look at each of those now. An information notice is a formal request for a controller, processor, or individual to provide the ICO with information within a specified time period to assist with investigations. The ICO may serve an information notice at its discretion in any investigation. And when deciding upon the period for compliance with these notices, in particular whether or not to issue an urgent notice, the ICO has regard to what action is appropriate and proportionate. So those are the key phrases in relation to investigations. And criteria will include there's various criteria, including the following. So the extent to which an urgent investigation may prevent or limit the risk of serious harm to individuals or serious intrusion into their privacy. For example, think about the ICO probably requesting an early report on a serious data security breach in order for them to advise the controller on the breach and potentially mitigate any harms. Another criterion is the additional burden on the recipient of having to comply with a notice urgently. So kind of broad brush criteria around appropriateness and proportionality there. If a recipient of information notice does not fully respond within the applicable time period, whether urgent or not, the Commissioner may decide to apply for a court order requiring a response. Now turning to an assessment notice. This is issued by the ICO to a controller or processor to allow it to investigate whether they comply with data protection law. The notice, for example, may require the controller or processor to give the ICO access to their premises. And again, similar to information notice, the ICO may serve this at its discretion, though will have regard to appropriateness and proportionality, including other kind of criteria such as whether there's information in the public domain, so news reports, statutory reporting, or publications about the controller or processor, which might suggest they're not processing the data in compliance with data protection law. In addition, the ICO may decide whether or not to issue an urgent, no notice, or short notice assessment notice. Okay, so what types of documents can the ICO request as part of its investigations? Broad range, unsurprisingly. So these, in our experience, typically include policies, procedures, training material, contracts, privacy statements, privacy impact assessments. Worth noting that privileged communications, so legal or litigation privilege, are not subject to access by the ICO. So turning to the scope of an investigation, what will an inspection or an assessment actually encompass? So first, there will likely be reviews of personal data to evaluate how an organization conducts its data processing activities, so how it obtains the data, how it ensures the confidentiality of the data or the service the organization provides, and how it destroys the data. So kind of general understanding of how it handles data. Second, there might also be a review of kind of management or control information to understand how the data is handled in practice and how an organization meets its broader obligations under the law. Third, The inspection or assessment might take into account the physical and IT related security measures put in place by the organization. And fourth, uh, likely the investigation is likely to involve some element of interviews to understand the working practices and awareness of regulatory obligations within the organization. So in our experience, these interviews can typically be held with operational staff, legal staff, support staff even, so IT support, security support, as well as kind of more obvious data protection representatives within the business, such as a DPO or legal team. So that's some of the more formal elements of the ICO's investigative processes. But in practice, what action does the ICO take in relation to organizations? So, and this is taken from um, the regulator's 2019-2020 annual report, in which it set out that it conducted over 2,100 investigations. There were 54 information notices issued, 8 assessment notices were also issued. So clearly showing that the regulator takes a more kind of informal approach to investigations, informal. 2,100 is obviously a sizable number, um, and there's clearly a kind of awareness there that if a matter can be resolved informally first or investigated informally first, which may of course lead to sanctions, then that's preferable to um, issuing strict kind of information notices and assessment notices, though of course the ICO reserves the right to do so. So an online inspection is evidently a high profile and significant event for an organization's data protection compliance activities and risk profile. Therefore, I just want to run through some general practical steps in the event that this happens to your organization. Worth noting at the outset that an inspection on site can be with notice or without notice. So on arrival of the investigative team, um, it makes sense for a representative of the organization to verify the identity and authorizations of the DPA's agents. So make copies of their ID documents and authorizations and keep a record of the names, positions, and times of arrival. Second, key to alert the data protection officer, or if there isn't one within the organization, then a kind of senior legal representative. If they're on site, obviously attendance in person would be preferable. If they're not on site, trying to get them on site quickly, again, would be preferable, or at least dialing in remotely and speaking to the DPA's relevant representatives. At that point as well, it's key to ensure that the organization is crystal clear about the reasons for the investigation. So what are the justifications, the alleged non-compliance, so that then in the background, the organization can start to respond and react to the alleged non-compliance. So also important to form an investigation team that could, or prudent organizations will have that in advance. So a kind of lineup of representatives who might be able to respond in the event of an on-site inspection. If that's not been organized in advance, then makes sense to put that in place quickly. And ideally, the team should have a good knowledge of data protection, a good understanding of the data processing activities which are carried out by the company, and also kind of sufficient permissions to access documents and databases subject to the inspector's queries. In our experience, typically this team is composed of a representative from the legal department, one from the compliance department, one from the HR department, and finally a representative of the IT team. Important to note that, and this is all kind of subject to local law, but DPA representatives are often not legally obliged to wait to start their investigation until, say, the DPO arrives or the investigation team arrives. But requests can be made that they wait for a short period to allow the organisation to put those kind of necessary people in place so that they can ultimately respond to the investigation in a more expedient manner. Okay, so during the investigation, an organisation should seek to be cooperative and take the necessary measures to assist DPA representatives with their work. That said, of course, they should ensure that searches conducted by the DPA are within the scope of their authorizations and don't pose any kind of security threat if there's access to database, etc. The DPO should also seek to complete an ongoing report of the activities being undertaken by the inspectors, and bear in mind that the point I made previously about privileged communications being restricted and therefore inaccessible, as well as also carefully considering any request to take data or information off site, which might also not be required under local law. There's also another kind of broad point around providing access to data to the inspectors which isn't reasonably accessible. Um, so question around kind of timing for the provision of that as well. On departure of the representatives, the DPO or the investigation team should or the company's investigation team should complete a report of the investigation and or inspection rather, and where possible have it kind of recorded or minuted by the DPA for kind of factual accuracy. Query whether that the DPA will agree to that in practice, but potentially worth making the ask. There'll be some external and internal discussion about the inspection, especially if it's high profile. So the organisation should probably draft some internal communications for staff who are implicated to explain what's happening, and also to provide a kind of party line on how to speak about the inspection externally. Also worth probably drafting some external communications in the event of any media attention about the inspection. Okay, so that's the practical elements of an inspection. Now just to conclude with some general pointers on dealing with an investigation more generally. So first of all, seek to put your best foot forward with the regulator. Seems kind of common sense and obvious, but in the panic and rush of an investigation, often the basics are forgotten. So in order to do this, you need to ensure at the outset that you're crystal clear on the reasons for the investigation so that you can try your best to explain your approach to the regulator and potentially try to put your side of the story across as quickly as possible before a narrative potentially develops, which is difficult to influence thereafter. Second, understand and be informed about the regulator's priorities. So are you within a sector or industry which is attracting particular scrutiny or where the DPA has issued recent enforcement action? Study that so you're aware of risk areas and mitigating factors and lessons learned, and potentially what enforcement might result from the investigation into your business. And finally, ensure consistency of messaging and response. So again, another common sense point, but ensuring that all of the organizations on the same page is key so that your argument and the story and the reasons that you're putting across and conveying to the regulator are kind of consistent and coherent. Um, yeah. Okay, so that concludes the bulk of the session. Now you should be equipped to explain data protection regulators' investigative powers, explain the UK ICO's general approach to investigations, understand how to handle an inspection, and provide general pointers on dealing with an investigation. That completes segment 6 of the 7 in this module, and our next segment will be accountability and helpful privacy program tips. So thanks for watching and listening to this session on how to handle a data protection regulatory investigation. As ever, if you've got any questions, feel free to get in touch with me. My contact details are provided there, or your relevant contact within Fieldfisher. Thank you very much.